Can you tell me a story?
Sure. Once upon a time, a mom needed a new car.
Was she brave?
She was tired, mostly. But she went to Carvana.com and found a great car at a great price. No secret treasure map required.
Did she have to fight a dragon?
Nope, she bought it 100% online. From her bed, actually.
Was it scary?
Honey, it was as unscary as car buying could be.
Did the car have a sunroof?
It did, actually.
Okay, good story.
Car buying you'll want to tell stories about. Buy your car today on
Carvana.
Delivery fees may apply.
Insurance isn't one size fits all. That's why customers have enjoyed Progressive's Name Your Price tool for years now. With the Name Your Price tool, you tell them what you want to pay, and they'll show you options that fit your budget. So whether you're picking out your first policy or just looking for something that works better for you and your family, they make it easy to see your options. Visit Progressive.com. Find a rate that works for you with the Name Your Price tool. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law.
I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Welcome back to the Prosecutors Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my pooty poot of a co-host, Brett. My pooty co-host.
This is like the case will never end. I feel like, you know how some podcasts and some YouTube channels, they really become obsessed on one case, and they do like 1,000 episodes on that case. And I never thought we would be that, Alice. And yet, it seems like the Murdaugh case is the case that just never lets go. We just can't quit it. It just keeps coming back.
We can't quit it. We keep trying. You know, the cases we want to quit never quit. And this one, I thought we really left behind. I thought this was a chapter of our lives. We recorded every night. We followed the trial. I had a baby right at the verdict. I mean, I held on having a baby to have the verdict, and then we were done. The prosecution did a fantastic job. The shenanigans, we covered it all. But it's okay because justice was done. The jury came back guilty on all counts. He, being Alec, Alex, Ellick, Murdaugh, was sent to prison for life. But as we know, today is a big day because something has happened that we tell you never happens. We say there's going to be clickbait. Every filing, someone's going to say someone's conviction is going to get overturned. They're going to get a new trial. We say it's really not what's going to happen, except it happened today in Alec Murdaug's case. His conviction.
Oh my God, Becky.
Just keep playing it. Just keep playing it because, oh my God, Becky, this is your fault. This is all your fault, Becky Hill. If you don't know what we're talking about, we'll dive into it. Don't you worry. But just know, what we tell you never happens, just happened.
Yeah, and, you know, I will say this. I think we had made clear that if Ellick was going to get a new trial, it wouldn't be because the evidence was weak or because the judge made a mistake or something along those lines. It would be because Becky Hill, the courtroom deputy in Colleton County, where this was tried, decided this was her moment of fame. This was her opportunity to go big. It had never happened before, and it was never going to happen again. This was the moment to strike, and she decided now was the time to write a book.
And for those of you who think that we are embellishing, no, we are not. So, of course, Becky Hill was the county clerk. I forget the official name, courtroom clerk, what have you. She's a public servant who serves the court. And she has since this all came out, she has since pled guilty to the fact that she did, in fact, perjure herself when she denied the fact that she showed evidence to the media, including sealed evidence. So she lied to the court.
Oh my God, Becky.
Yes.
This is bad enough.
Not all that she's lied about, of course. But just so you know, this is not embellishing. This is, in fact, she has said multiple times to multiple people who all testified under perjury that she was writing a book and that a guilty verdict would help her sell more copies. And in fact, she made comments throughout the trial to courtroom staff as well as to jurors about the weight of the evidence, which you cannot do. No one can do that. And basically saying along the lines, and we'll go into exactly what she says, to watch when Alex Murdaugh takes the stand, not to believe the defense that they're putting up and don't let him get away with it, and things to that effect, which the Supreme Court has decided shows prejudice. Now we'll analyze, what the Supreme Court said and how it came to this decision, because this is not what the court below found. There was an evidentiary hearing below, of course. We said that there had to be a record built here. There had to be evidence, not just affidavits, of what the jurors heard, not heard, and whether it affected their decision, because we've said all along, this is a two-prong issue. It's not enough to show that Becky Hill said things that were improper. There's always the prejudice prong. You have to show it actually had an effect on the verdict.
And we talk about that a lot when we talk about these appeals. There are always mistakes in trials. Sometimes people do things intentionally that are bad in trials. But when you have an appeal, you have to show it's not good enough to show there was a mistake or an error or even an intentional mistake. I don't know how to describe what Becky Hill did, but you also have to show prejudice. And that was a big part of this case. This case is obviously sensational because what it means in the Murdaugh saga, which has become one of the most famous true crime cases in American history. But it's interesting also for just the procedural, nerdy stuff about appeals, because Alice is right. When this was initially raised, because basically what Murdaugh did, he files an appeal, and it's your standard appeal. Oh, they let too much financial information in. Oh, they shouldn't have let this expert in, and this was prejudicial, and the evidence wasn't sufficient to show I'm guilty beyond a reasonable doubt. They make that appeal. It goes up to the Court of Appeals in South Carolina, and then all of a sudden, bombshell. They're having a press conference. They're asking the Court of Appeals to hold that appeal because they're saying they have this serious jury tampering issue. And initially, I think all of us are like, oh, whatever. They've got egg lady juror saying that someone was prejudiced and big whoop-de-whoop. This happens.
By the way,
all the time.
egg lady comes up in a footnote in the Supreme Court opinions.
As egg lady. She's called
As egg lady and egg juror.
Yes. It's just wild. Anyways, so we think no big deal. But then as the details leak out, all of a sudden you have this incredible charge that Becky, who had attained some sort of fame in the small sense, and people saw her every day. People thought she did a really good job, that she ran the courtroom well. People called her Miss Becky. They liked her. Everybody thought she's just another part of this courtroom staff who was doing a great job. The judge, everyone loved the judge. The judge is fantastic, and this does not reflect on him at all. It just felt like, how is it possible that Miss Becky could have done something wrong? And then Harpootlian, Pooty Poot, he comes out and he starts saying, we have affidavits from multiple jurors who are going to say that throughout the trial, and in particular in the run-up to Alec Murdaugh's testimony, that she was saying things about not trusting him and the defense is lying to you. And this sort of widespread of statements. So some of them were a little less egregious, just like, oh, the defendant's testifying, it's going to be a big day. Maybe that's not as big a deal. But then statements like, he's going to lie and don't let him fool you. And those statements, if those are true, that really feels like jury tampering. And so this allegation is made. And initially, the judge recuses because he's kind of a fact witness. And this retired, I believe, Chief Justice of the Supreme Court, Judge Toll, she comes in and she handles this initial hearing.
So this hearing, basically what we said when there were just the affidavits is they're kind of all over the place. It's not exactly here. And this is why you have an evidentiary hearing. So you can put the jurors or the witnesses on the stand and you can cross-examine. And essentially they have 3 jurors, one who was dismissed, egg lady. Their testimony is really discussed at length. So if you remember, just to remind you, juror X gets on the stand and says that Becky Hill says it's going to be a big day. Okay, big day, kind of epic day, these sorts of things. The really bad testimony comes on with juror Z. So juror Z wrote an affidavit and it gets on the stand and affirms all of this. And I think may even have an amended or supplemental affidavit after the fact with even more kind of damning facts. Essentially, juror Z gets to the prejudice prong because juror Z says that she actually felt pressure to vote guilty because Becky Hill told the jury when they went to go deliberate, quote, this shouldn't take long. And when Murdaugh was testifying, to watch him closely, that sort of thing. So though that really goes to the prejudice prong, we always said you have to get the prejudice prong, because if everyone's like, well, yeah, crazy Becky standing over there saying it's an epic day. Everything's epic. It's epic. It's McDonald's day. It's epic. Murdaugh's testifying. It's epic. There's a cat outside. That may not mean anything. But if it then affects a verdict, that's what Murdaugh's team had to show. And they had at least one juror who was willing to get on the stand to say that.
So the thing about this is whether that juror was telling the truth became really important, because essentially what you had here, you had a couple alternates who had filled out an affidavit, one who had been dismissed, egg lady who'd been dismissed, then another alternate. Then you have this juror Z, I think it was Z, who was an actual juror. And the interesting thing about juror Z, it seems like she was the only one who had any doubts, that the other 11 jurors went in and thought he's absolutely guilty. And she says in her affidavit, not only did she feel pressured by Becky Hill, but she felt pressured by the other jurors. Now, that's not a real thing. That's what we call deliberations, when you sit around and you talk and eventually you come to a conclusion. But it was always interesting to note that the one juror who voted was the juror who seemed as though she had maybe some doubts going in. And she's the only juror who voted who's saying Becky Hill said the more egregious things. And so in this hearing, you have all these other jurors who come up and they say, I never heard that. She never said that. Nothing like that. And then you have Z who comes up. Her testimony is a little equivocal. As Alice said, she basically gives an affidavit that's like, man, that's pretty rough. Then she testifies and it's not as clear. She's questioned by Judge Toll, because Judge Toll did all the questioning of the jurors. It's not as clear. Seems like maybe the pressure was more from the jurors. She then leaves. She then submits this supplemental affidavit. And the thing about affidavits is ordinarily they're what you need to get into court. But once you get into court, you need to testify about it, because otherwise it's hearsay. Like, we want to hear from you. So there was this confusion in the Supreme Court's opinion about whether or not to credit the affidavits. And one of the things that was really interesting about the Supreme Court's opinion, and we're about to sort of dive into it, by the time you get to the end of it, I think this was a case where the Supreme Court decided Becky Hill had done really terrible things. And honestly, that's beyond question. She's pled guilty to lying about violating court orders and doing things to get into the good graces of the press. She'd done really bad things. It had undermined confidence in the judicial system and in this conviction. We're going to overturn this conviction. In order to do that, they had to play fast and loose, both with their own precedents and with the credibility determinations and the factual determinations made by the lower court. As you may recall, when we discussed the lower court's ruling, one of the things we said was, it's going to be really hard to overturn this because this judge has papered her decision so well. She's pointed to a lot of factual determination she's making. Yes, they're difficult legal questions, but the way she's presented it is either way, the state is going to win. If you believe that they have to show prejudice, that Murdaugh has to show prejudice, well, he hadn't shown it. If you believe that prejudice is presumed, well, the state overcomes it. And here's all the reasons I don't buy the things that were said by these critical jurors. And it gets up to the Supreme Court. And when you listen to the argument, it became pretty clear that the Supreme Court was open to ignoring a lot of those factual determinations that ordinarily are binding on the Supreme Court and get back into that. And I think you saw this where the court really is reweighing that juror's credibility, considering those affidavits in a way that I don't know that they would in any other case, so that they can come to the conclusion, number one, that Murdaugh has the better argument about how prejudice works, that you really only have to show sort of a prima facie case. And if you do that, then prejudice is going to be presumed. And at that point, the state has to rebut that presumption, either by showing that that didn't really happen, and we'll go through the standards, or that it wasn't really that serious, or that the weight of the evidence is so heavy, it overcomes whatever it is that was said. But at the end of the day, the Supreme Court said the state failed to do that. You're listening to this podcast, so I know you've got a curious mind. Here's a helpful fact you might not know yet. Drivers who switch and save at Progressive save over $900 on average. They make it super simple. Pop over to Progressive.com, answer some questions, and you'll get a quick quote with coverage options tailored to your choices. Plus, you'll see which discounts you may qualify for, like the online quote discount or savings for paying in full. In fact, 99% of Progressive Auto customers earn at least one discount.
See if you could save when you switch to Progressive. You'll feel good about making a savvy choice. Visit Progressive.com and see if you can enjoy a little extra cash back. Progressive Casualty Insurance Company and Affiliates, national average 12-month savings of $946 by new customers surveyed who saved with Progressive between June 2024 and May 2025. Potential savings will vary.
You're listening to this podcast, so I know you've got a curious mind. Here's a helpful fact you might not know yet. Drivers who switch and save with Progressive save over $900 on average. Pop over to Progressive.com, answer some questions, and you'll get a quick quote with discounts that are easy to come by. In fact, 99% of their auto customers earn at least one discount. Visit Progressive.com and see if you can enjoy a little cash back. Progressive Casualty Insurance Company and Affiliates. National average 12-month savings of $946 by new customers surveyed who saved with Progressive between June 2024 and May 2025. Potential savings will vary.
You can't predict the future, but you can prepare for it. Arizona State University is building degrees for what's ahead, taught by world-class faculty who are shaping our future. Explore over 350 programs offered online at asuonline.asu.edu.
Which, if there is that presumption, man, it really in a lot of ways erases that prejudice prong because of what we're about to see. Because the court assumed the following comments did happen. We hold Murdaugh established Hill made comments that the day Murdaugh testified was, quote, epic or, quote, important, and urged the jurors not to be, quote, fooled or confused, thrown off or convinced by Murdaugh, and to watch Murdaugh's body language closely. So that's what the court assumed happened. For what it's worth, and they base this on the fact that she has credibility issues in herself. It's never going to get old. That's part of it. Because, oh my God, Becky.
Oh my God, Becky.
You pled guilty to perjury already. So her credibility is really shot at this point. And they say that, well, we're hearing it from multiple jurors. They don't discuss, by the way, the other jurors who all testify and say nothing happened. So when you read just the facts based on the Supreme Court opinion, it does look really bad because they don't say, well, you know what? There's this one juror that went in and the only voting juror who said that they had any sort of doubts going in, but actually everyone else who took the stand said, we didn't hear Becky say that. And it's really interesting because they actually say, this is where the credibility, you see them weighing it. They say, well, there's all these other people who testified, court staff. You can talk to court staff, by the way. Court staff can talk to court staff, no big deal. But other people who rode home with Becky Hill, not jurors, other people who worked in the courtroom with her, noted that, yeah, she did say things like that, like, Murdaugh, better watch him, or it's going to be a big day. Similar comments to what they now assume happened to the jurors. And they said, now, because she said it to other people who she's allowed to say it to, by the way, we're just going to presume that means she definitely said to the jurors here as well, even though at the time the jurors didn't say anything about this. That's really interesting because if that's not a credibility determination, no, I don't know what is, especially since those other people, I can say things that are appropriate and then choose not to say them in inappropriate instances. But here they're kind of saying, because you said it in this instance, she said it to the jurors.
And, you know, one thing that they did, and this irritated me in oral argument, and they carried it through into this opinion. So Creighton Waters, in his argument to the Supreme Court, said there were 11 jurors who said this didn't happen. There's one juror who deliberated, who kind of said it did, who was equivocal at the hearing, who's contradicted herself at the hearing. And the judge's credibility determination was not invalid. It wasn't obviously incorrect because you can reweigh credibility if the lower court judge is so obviously wrong. Like, no one would buy that. And so Creighton's saying, look, she's not so obviously wrong because she heard 11 jurors say this didn't happen. And then she hears one equivocal juror say it did. She's able to take the 11 and find them more credible. And the Supreme Court kept saying, well, you know, there's a Supreme Court case that says you're entitled to 12 impartial jurors, not 11, not 10. Are you saying, oh, 11's good enough? And one of the justices kept saying that. Well, you keep saying 11's good enough. That is never what Creighton Waters said. That was not the argument. They make the same false straw man argument in their opinion. The argument was
They
always...
inflate it, actually. They say it's 3 jurors when it's really just 1 juror. Because I had to go back and say 3. Wait, Egg Lady's one of them, dismissed. And then juror X didn't say there was any prejudice and really just said it was a big day, which big day could be fine. So I thought they did worse in their opinion. Not only did they build up a straw man, but then they inflated it.
Now, one thing they did do, Alice read you the part of the opinion where they say, this is what she said. So they don't go as far as to say, she definitely said the defense team's lying. She definitely said Murdaugh's guilty and you should convict him. They don't go that far. So they take sort of a middle ground. Whereas I think Creighton Waters' position was, yeah, she probably said this is a big day and it's important. And, you should watch him closely. But that's fine. Even if maybe she shouldn't have said that, that's a neutral comment. It's a neutral comment. It's not necessarily saying he's guilty or not. But the fooled, confused, thrown off, don't be convinced. That's really the problem. So the question is, now that we're assuming she said that, so we've got the factual basis, that's what she said. Do we need to have a new trial? So the court applied this 1954 Supreme Court case called Rimmer. Now, the thing about Rimmer, and we talked about this several episodes back, we've done so many episodes on this now. So Rimmer is an older case. Just because it's an old Supreme Court case doesn't mean it's not a good Supreme Court case. Marbury versus Madison's 250 years old, right? But it's an old case. A lot's happened since then. There's been a lot of Supreme Court development. It was a very sort of strict case about prejudice, really kind of said, really, if there's any outside interference at all, there's prejudice and you should reverse. The courts in South Carolina had not really applied Rimmer in that way. And the Supreme Court acknowledged that in its opinion, that they had not been consistent in applying Rimmer. There were arguments that successive cases, Olano, for instance, had undermined Rimmer and that really this presumption of prejudice was too strong. But the Supreme Court in South Carolina eventually comes around and says, hey, no, we think Rimmer's it, and we're going to apply Rimmer pretty strictly in this case, and we're going to use it to look at prejudice. Now, another thing they did, which I didn't like at all, they said the trial court erred in asking jurors whether any of Hill's comments affected or would have affected their verdict. And they said, look, okay, there's a rule of evidence that says you shouldn't look into the jury's verdict. Totally get that. But to me, when the defendant puts it at issue and then puts the whole thing we're discussing here is whether or not these comments affected the jury, not asking the jury, that seems pretty strange. And actually, in order to get there, the Supreme Court had to overrule a prior South Carolina Supreme Court case that had said you could do exactly that, which is another, the trial court judge is operating under your precedent, doing what your precedent says she can do. And now you're overruling it. But I think this sort of points to the Supreme Court, I think, kind of reached the decision that it thought was the right decision and then kind of reasoned backwards from that and overcame whatever obstacles it had to overcome to get to that point.
Yeah, and I think and we can talk about this later. It's a separate question whether, I don't like outcome-driven, working backwards types of cases, but we can talk about what this means for trials now in the social media age and when people are writing books and getting, Netflix deals and all these sorts of things around trials that have to do with people's constitutional rights. We can talk about that, but I agree with you, especially when you're seeing them kind of overturn their own precedent to chastise a judge, and then we'll talk about their guidance later, something that, courts are not supposed to do. But before we get there, there's just so much to talk about. So back to Remmer. In applying the Remmer presumption, the court considered a number of factors: the extent of the improper communication, the extent to which the communication was discussed and considered by the jury, the type of information communicated, the timing of the exposure, and the strength of the state's case. This is a big one, the strength of the state's case.
Can I just say?
Yeah, go for it.
Real quick. How do you consider the impact of the communication on the jury without asking the jury what the impact of the communication was to them?
Well, now they're just asking crazy questions like the trial court did in this case. How dare you? Yeah, I agree. I agree with you completely. That is the very heart of the issue of whether there was prejudice, whether it affected their decision making. And it, in fact, would be very difficult if you didn't ask that question. So given the court's factual findings that we talked about earlier, assume that Becky Hill made all these comments. It's unsurprising, of course, that the court found the first factors overwhelmed the final one. And the final one is a big one. It's the strength of the state's case. And that's what Creighton Waters really emphasized in the oral argument. You know, we do these wrap-up cases where we do one episode of all the evidence against someone. That's essentially what Creighton Waters did near the end of his oral argument. And it was very well done. The strength of the evidence against Murdaugh was overwhelming. Based on the presumptions this court made, as I was reading the factual findings and their explanation of Remmer, I was like, oh, there's no way under the way they're explaining what the law is, there's any set of circumstances the state would have overcome this last prong, which is that there wasn't prejudice because of the strength of the case. And so when I read to the very end, and if you read this opinion, which you should, the majority of the opinion is spent on the comments that Hill made, explanation of the law and how they have to overturn their own precedents. And then the actual prejudice prong is like a paragraph. Mm-hmm. I actually went back. I was like, you know, sometimes you zone out when you're reading. I was like, I must have zoned out because this is a really important. I thought 3/4 of the opinion was going to be on prejudice. And essentially it was boiled down to the fact that jurors heard this. The fact that jurors heard this, it didn't matter that there was a strength of the evidence in this case. There was no set of evidence that was ever going to show there wasn't prejudice. So essentially, because of the first prong being met, the second one was swallowed up in the first one based on the way this opinion was written.
And it's true. I mean, they really don't grapple with the strength of the evidence, which is one of the prongs. Honestly, we just read you the prongs. That's how you consider it under Rimmer. Judge Toll, I don't know if she was a justice. She used to be a justice. She was a judge when she did this. I don't know what we're supposed to call her.
I feel like once you're a justice, always a justice.
Always a justice. Justice Toll. She really did that. I mean, she really went through those prongs and talked about them. I mean, she talked about the extent. She reached conclusions about that. She talked about how much this was discussed and considered by the jury. That was one of the things she did that she gets slapped down about by the Supreme Court. And she put a lot into the amount of evidence that came in, whether or not there's true prejudice here. The Supreme Court of South Carolina, really, they described this as a burden shifting thing where the burden's on the defense to prove something, then the burden shifts to the state, and then the burden's on the state to rebut it. And then if they can do that, the state's going to win. They describe it that way. But really, if you read it, it reads like if the mistake is made, intentional error, whatever, malfeasance, whatever you want to call it. If it happens, if there's an outside person, I guess particularly someone who's affiliated with the court who interferes with the jury, you're going to get a new trial. It didn't really feel like there was much opportunity at the end of the day for the state to really overcome that. Once the court decided how prejudice was going to be applied, that was it. It's almost like we talked about before, standards of review and whether or not something is under strict scrutiny or whether it's rational basis and how that often decides the substance. If it's rational basis, the state's going to win. If it's strict scrutiny, the state's going to lose. That was kind of the way it felt here. It's unclear to me that the state could ever have overcome the prejudice once the court found it. I don't know what the state could have done to overcome it, particularly given what they have in the factual record.
And to be clear, I don't think it was necessarily a slam dunk for the factual. Like they only gave one side. So the factual presumption they had there, once they set it up like that, and you can see it in what the court says, right? They say, the breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. Yes, I agree. Oh my God, Becky.
That's the most important line in the entire.
That is the most important line because that line had nothing to do with prejudice. It had everything to do with the fact that this is a complete disgrace on the entire South Carolina judicial system. This is horrendous, you know, if Becky did what she did and presuming that she did. But they were going to reach this result that he was going to get a new trial because of what they said right here, not because necessarily the prongs were met under Remmer. It was because it was a breathtaking and disgraceful effort of Hill to undermine the jury process, which is unprecedented. That's why they decided it.
Basically, what the Supreme Court was saying was,
Oh my God, Becky.
And that was enough for them. And look, there's an argument that they're right, that it's just important to send this message that this is absolutely unacceptable. It basically is a structural error. That's the way we're going to treat it. And if you're somebody who works for the courts and you're going to do something like this, you're going to be embarrassed. You're going to be disgraced. Your career is going to be destroyed. And the cases you worked on are going to be undermined and destroyed because of what you did. And there's an argument that that's what they should have done. I definitely think they may suffer for this in the future. I think they'll actually end up narrowing this. I think this case, if this were a street level drug dealer in Charleston, this never would have happened. They would have, whatever the trial judge said, they would have credited and they would have denied the appeal. But because it's Alec, as one of the justices referred to him by his first name throughout the entirety of the argument, not given, a lot of faith there, because it was such a big deal, because it was a national story, because it was so embarrassing what she did, because frankly, we kind of keep learning about her malfeasance throughout this. I think they just thought, we got to clean the decks here. We got to do this again. And that's just what has to happen. And I get that. I mean, I totally see what they're saying.
They could have slapped her down in the worst opinion that was like, if ever a case were won, but we hold true to the law. And the strength of the evidence is also as overwhelming as Hill's unprecedented malfeasances, something like that, right? Like they do. They name her by name. They talk about how she's pled guilty to perjury. They talk about her at length. In fact, I don't know that this opinion properly slapped her down, to be totally honest.
It's true.
They spent more time on funny footnotes, really, about Egg Juror and Egg Lady than on Becky Hill. And there was a little bit, they had a footnote about Becky Hill that was a real jab that was like, you know what? The book got pulled because she plagiarized large swaths of it. It had nothing to do with the opinion. So they took little jabs at her. But honestly, this opinion did less chastising of Becky Hill than I thought it could have done, especially if the purpose of this opinion was, in fact, to discourage all future public servants of ever trying to sell out justice in order to make a quick buck on a book or some sort of movie deal. And I thought they kind of lost the ball there. Yes, the result probably will have that effect. But Becky Hill kind of got off easy on this opinion, to be honest. I would have been a little bit harder on her. And let's not lose sight of the fact that they didn't grapple. Another way to deal with this is we've seen this in the Delphi, Indiana Supreme Court opinions, for example, where they deal at length with the strength of the evidence. There wasn't a single footnote. There wasn't even anything about the fact that, Alex Murdaugh testified and he was found to be lying and that the phones would only move when he did and his phone betrayed him and all these things. And hello, the strength of the evidence was immense, but none of this. They didn't grapple with any of these things. But you know what they do grapple with? They do something that we also tell you courts are never supposed to do. What are they supposed to deal with? Case and controversy. What does that mean? Something that is properly before them where they have to make a decision on. They are not supposed to do something called advisory opinions or guidance over something that's not before them, Brett, right?
That's true. But this case wasn't just... The Supreme Court also decided, in their opinion, to issue guidance to the judge on retrial about the financial crimes evidence. This is very strange. So ordinarily, what you would do, if you're going to reverse, because you got Becky Hill, you just reverse. Now, ironically, the Supreme Court or someone in the Supreme Court leaked this decision. Don't know who it was. Don't know if it was one of the justices. Don't know if it was one of the clerks. But someone in the Supreme Court of South Carolina leaked this decision. We knew, we didn't know because you always hope rumors are not true. But turned out they were. Last week, it was leaked that the Supreme Court was going to reverse this conviction because of Becky Hill. And that it also was going to limit the financial information on retrial. We can talk about the leak in a second. But as to the financial information, a lot of people took that to mean...
Ironic, because we're dealing with, obviously, malfeasance here by a court staff.
You would hope them doing this would have sent a message to their own staff, not to leak to the press about what's going on in your court. And I wonder if they have dealt with that.
Be on the lookout for a book in the next 6 months, guys.
Yeah, exactly. This whole case is not South Carolina's finest hour, but that in particular was shocking. But some people were concerned they'd keep the financial information out altogether. And that's not what they're going to do. And their guidance doesn't do that either. what they basically said is, and they're right about this. I actually think this will make the state's case stronger. They basically said, look, when it comes back and the judge is trying to decide what all to let in, and they make it pretty clear this is admissible. At some point they say, now just because we're saying it's admissible doesn't mean the trial court has to say it's admissible. It'll be up to the trial court. Okay, the Supreme Court unanimous opinion says it's admissible, but I'm going to say it's not. Basically limit it to some extent, that it was too deep, it went on too long. 100% correct. We talked about that when it was happening, that they were, I thought, to their detriment going too long, because it's like the jury gets it.
It was cumulative, but purely within the purview of the trial court.
Well, it is, and that's why they're giving guidance to the trial court. So, a very strange thing. You don't really see that often in a Supreme Court opinion. But I think what the Supreme Court is attempting to do is to say, look, we have overturned this one time because we felt like we had to. We really don't want to ever have to overturn this again. So we're going to go ahead and just point out that when this comes up, they ignore all the other issues, which tells you none of those issues were serious.
If they would have grappled with it. But like, we're very concerned by the fact that, and they don't.
Exactly. No guidance on like the expert opinions and everything else. Just guidance on the financial stuff. So the guidance is cabin it a little bit more, keep it a little bit more on motive itself, but it's going to come in to the extent there ends up being a retrial in this case. And I just want to throw something out there for the world. So the state of South Carolina, through their attorney general who's running for governor, has already said they're going to retry this case. And I assume Graydon Waters is going to retry it because he was arguing this in front of the Supreme Court if it happens. But here's the thing. Some of you have wondered, is Murdaugh going to get out? No, he's not, because he pled guilty to extensive financial crimes in federal court and got a 40-year sentence. He's, I think, in his late 50s, 56, 57 years old.
He doesn't look good, by the way.
Yeah, he doesn't look great either. In federal prison sentences actually mean something. You have to serve at least 85%. You know, if you're good, you can get that 15% off. But you got to serve at least 85% of your sentence. So you got a 40-year sentence. He's going to serve the vast majority of that. He's probably never going to get out anyway. One wonders, what was the purpose of this? You know, Pooty Poot said, nobody wants to retry this, including us, which, okay, whatever, Pooty Poot. I always thought that Murdaugh's preference was, if he's going to spend the rest of his life in prison, federal prison's where he wants to be. He wants to be in a federal prison. He doesn't want to be in a South Carolina prison for the rest of his life. I think there's an opening here, given that this state conviction has now fallen away. Now, he has financial crimes conviction in a separate case as well, but I think the federal one would take precedence over that. I could imagine a world in which, if it's agreed that he can serve his sentence in federal prison, he does something like a Alfred plea to 40 years on the murder. So then he doesn't admit guilt. He can maintain for the rest of his life that he didn't do it, but there doesn't have to be a retrial. He doesn't have any money anyway. So I guess Buster would have to loan him some cash. And part of the agreement would be he serves his time in federal prison, not state prison, and then he gets to go off to federal court. I could imagine that being a resolution that he would find potentially attractive. But who knows?
He would find that attractive. I agree with that. But so the reason I wouldn't be completely opposed to that is because there's already been a trial and all of the facts have already come out on the public record and it's all been out there. Because one reason that I'm opposed to like an Alfred plea or a guilty plea in general is like, if they maintain their innocence and there isn't justice for everyone because the facts aren't out there. The facts are already out there. There's already lots of like documentaries made about it. We know really what happened. I don't know. If I'm Graydon Waters, I'm like, let's roll. Let's do it again because you are scum of the earth. I will deal with Pooty Poot again. Becky Hill, get out of South Carolina. You are no longer welcome here ever again. But that's just me. Maybe, you know, I'm just a woman with fury over here, but I want justice for his poor wife and son who he shot point blank in the face. And he should have to face that again because he said, yes, I did all those financial crimes. And all along, it's all about his ego and his reputation. And he doesn't want to be a murderer. He went so far as to hire someone to shoot himself in the face to escape having to say what scum of the earth he is. put him back on the stand. Let's rock and roll. That's how I'd go about it, but I'm also not there, and that is going to waste a lot of resources. So yours is the more sane way, but I am sick and tired of Alec, Ellick, and all he does to skirt away from responsibility. So I don't want to give him an Alford plea. That's me as the prosecutor. Sorry, Creighton Waters. If you decide that, I still think you're the best. You're awesome. But if I'm the prosecutor, it's guilty or let's rock and roll and go to trial.
And he was guilty and everything was taken care of. And then...
Oh my God, Becky.
Had to ruin everything. Now, a few interesting things about this. I mean, number one, I would not expect the state of South Carolina would be the one to offer this. I would think he would have to come forward and say, hey, let's cut a deal. One interesting thing that Carly brings up, theoretically, the state of South Carolina could seek the death penalty. I mean, we're in a new trial.
And we have all the facts out there, and we know what his rebuttal evidence is, and it's not good. Before we didn't seek it because it was the whole like, what would cause this upstanding man who owns this town, who has this beautiful estate of Moselle, what would drive a man like that to shoot his own son and wife? We can't imagine it. And we said it back then. Great tactic not to seek the death penalty because death penalty wraps up all sorts of things in it, right? A lot of people who don't violate the law see themselves in Murdaugh in the sense that they're a loving father, a loving husband. How could they do that? They look like me, right? We said that was a good tactic then. I don't know. Like I said, let's rock and roll. Let's go. I believe in the strength of the evidence.
Insurance isn't one size fits all. That's why customers have enjoyed Progressive's Name Your Price tool for years now. With the Name Your Price tool, you tell them what you want to pay, and they'll show you options that fit your budget. So whether you're picking out your first policy or just looking for something that works better for you and your family, they make it easy to see your options. Visit Progressive.com. Find a rate that works for you with the Name Your Price tool. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law.
Well, and you're right. So if you wanted to seek the death penalty, you would have to show you weren't doing it out of spite for having to do this again. But I think the argument you would make is the state has now had the experience of the first trial, sees how weak his arguments are, knows what the arguments are going to be, and realizes even through the development of the evidence in the first trial, just how heinous these crimes were. Evidence came out about financial things.
And also cell phone evidence came out, like as they were trying to unlock these phones, right? So they didn't have that when they first made the charging decisions going out there and what penalty they would seek, right? I mean, that was incredibly damning and strong evidence that the defense was unable to rebut. And now they know this because they had the chance of cross-examination. So they can reassess their case and know really the strength of the evidence. And also, honestly, how it played with the jury, except for Juror Z, who is, look, you're always going to have people who are like, I don't know. I can see it with my own eyes that he shot his own son in the face and had no remorse for it and still have doubts about whether he's guilty. Those people are always going to exist. But you can see how it played to the jury. And you have the benefit of the jurors actually being asked how they grappled with the evidence and credibility. So the Supreme Court may have been right on that point, like, we're not supposed to look at the inner thinkings, but the prosecution actually has the benefit of all the inner thinkings of these jurors, and they can use that to reassess what sort of penalty they will seek here.
And look, I think, honestly, what I truly believe happened here, I think Egg Lady was always a weirdo. I think she wanted to be on that jury for whatever reason. She was going to try and throw it for Murdaugh. I think that 12th juror struggled with some doubts. She got convinced by the other 11. She voted guilty. Then she felt guilty about that. She started to have doubts. She heard these claims. And then I don't think she's lying, but I think her memory of what Becky Hill said is not credible. I think she probably inflated a lot of stuff. And I think you saw that when she testified. So I don't even believe this really happened. I think Becky Hill was saying things she shouldn't have said, but I don't think it went to the extent that we've seen before. That's what I'll always believe happened. And I do think that the evidence is really strong. People are asking a question, which is a good one. What about his testimony? He testified in court, subject to cross-examination. That is a classic example of a prior statement that can come in. If he chooses not to testify, and even if he does, the state absolutely can play it. If he does testify, and this is why he's in such a difficult position, the state can use his prior testimony to rebut anything he's saying. They can point out inconsistencies. They can play that, and they will have a ton of time to analyze that evidence, to break it down, to figure out what parts are best for them. I mean, this is a absolutely stacked deck against him going in a second time, which is why, to me, some sort of resolution where he doesn't have to necessarily admit guilt and doesn't really add any time to him would be attractive to him and might be attractive to South Carolina, because this was a really expensive trial. It will be another long trial. It will put the survivors and Buster through a lot again. I think there's going to be some appetite for that.
And not even to mention how difficult it will be to seat a jury in this case now that documentaries have come out. The Becky Hill issue has elevated this even more into like the pop culture era, even if you hadn't heard of this case before somehow, because of all that's happening with today's opinion, as well as Becky Hill's malfeasance and now perjury conviction. It would be really hard to seat a jury.
I mean, I assume they're bringing that jury in from somewhere else. That it is going to be tough. It will be hard. And the problem with that, then you run into the issue you had in Florida with Casey Anthony, where the only people who haven't heard about this case are not the people you want on a jury.
I was going to say, they're going to be the egg lady kind of people. They're going to be coming in with like weird thoughts about probably you're going to get a bunch of sovereign citizens coming in, and it's not going to be good.
Yeah.
It's not going to be your typical juror of peers.
Obviously, if you guys have any questions in the chat you want us to answer, we will. Obviously, if this goes to trial, we will cover.
We're going to have to redo the shirt that says, instead of
Murdaugh.
I survived the Murdaugh trials, to I survived the Murdaugh trials again.
Again. Yeah, exactly. With Pootie Poot, Paw Paw, Max, the whole crew will be back.
Let me just say,
Murdoch.
Creighton Waters, if you're out there, you pour yourself another one. You deserve it tonight.
Oh, God.
Because it's going to be a long road.
Can you imagine? Can you imagine
the
having to try that
exhaustion?
again?
You know the letdown you have after trial, where just every piece of adrenaline leaves your body, and even if you win, it doesn't matter. You're just utterly exhausted in a way that you can't even explain to anyone who hasn't done it before, where you just want to face plant into the floor and sink lower. I can only imagine this feels 10 times worse than that.
Oh, I can't. I mean, they put so much into that. And if you've heard Creighton Waters talk about it at CrimeCon or whatever, just the effort. And I'll say this, though. I mean, that man, in his argument for the Supreme Court, he still had it. He still had all the facts. So he's ready. He's probably ready to try it next week.
That's why I said, if I'm Creighton Waters, I'm like, let's rock and roll. I'm ready for this. Because all along, I mean, really when Alec testified, if you remember back to the trial in 2023, people did question the principle of, like, how is it possible that a loving father can do this? Then he took the stand and opinions started changing in real time. They're like, who is this narcissistic, navel-gazing murderer? He did himself no favors, and it's only continued now. But
yeah, he doesn't have much of an innocence campaign. I don't think there are many people out there who think Alex Murdaugh was innocent the whole time and was framed by the 4-foot-tall little people with guns who were hired by the Mexican cartel to come murder his family.
I wonder if he testifies again, if he uses all the pet names again. Like
I
Paul
think he
Paul.
will.
He has to.
If he calls him Paul, they should pull out the prop. You called him Paul before.
And now you're calling him Paul.
Yeah. Yeah. I mean, look, somebody said they think he'll testify again. I think he has to. Because
I think he has to testify because of the video that will come in yet again, and because of the prior testimony. He's going to have to remember what he said and memorize everything he said.
Otherwise, he has to sit there while they're playing him testifying
and
in front of the jury.
Yeah. All right. Whew. Got a little heated again. What can I say?
Well, I mean, look, I don't really know what to say about this.
If you are in a position of trust in public service, do not do stupid things. No. Do not do stupid things. Do not try to write a book. Don't try to say stupid things out loud. Be careful where you say things. Don't post things.
Don't talk to the press.
Don't talk to the press.
Don't get in with those people.
Just do your job.
It's just, and I will say this, and the Supreme Court made clear to say this as well. The vast majority of people who work in the courts would never do anything like this. It's one of the reasons it's so shocking. I just can't imagine doing something like this. I will say this. Several people have said this. I don't know that anybody said this in the trial, but several people have said, I think she did it on purpose. I think Murdaugh paid her. No, come on.
No,
that didn't happen.
She cared about herself.
Exactly.
She just thought, well, Colleton County, this is the biggest trial of the year. And it was. Everyone else is going to cash in. Pootie Poot sure is. So why can't I?
Yeah.
That's all.
I think it's exactly what it was.
Stupid decisions that people make. I don't think there's some big grand conspiracy. I don't even think she thought she was going to get millions. I thought she was going to get her 15 minutes of fame, and she sold all of this for 15 minutes of fame. She wasn't even selling this for like millions of dollars. Not at all.
And you can see that because she self-published. Like, let's imagine a world in which Murdaugh somehow, despite the fact that we know his finances are an absolute collapse, has like $1 million he's paying to her in some sort of strange insurance policy where at the end encourage the jurors to convict me. And then if they do, I'll use that to overturn the conviction and get another trial. But I'm not going to pay the jurors to not convict me or pay you to get one juror to hang the case. I'm not going to do any of that. I'm going to do all this stuff. Imagine that happened and he gave her $1 million. Then she decides to self-publish a book as well. And, oh, by the way, she's leaking to the press random things to get in their good graces. No, this has all the hallmarks of a woman who, as Alice said, she saw that moment where she could chase fame and she decided to do it.
And it's possible she had really bad judgment in other cases, but I don't think this is like some rampant Becky Hill thing. I think it was this case.
Exactly.
This was being televised. It was being live streamed. There were YouTube channels dedicated to the Murdaugh trial. This was the biggest thing to happen in Colleton County, the biggest thing to happen in Becky Hill's life. So maybe she did do this in all her other cases, but I don't necessarily think so. I think it was this case. She had never been in the bright lights before, and the bright lights were too bright for Becky Hill. I have nothing else to say. This is disappointing for justice because the weight of the evidence was immensely overwhelming. The conviction was right. Alex Murdaugh murdered his wife and son for his own personal gain. It had to do with the financial troubles that he was in, that the Supreme Court opinion guided on, that will be allowed in for any retrial. But he is in prison. He's not getting let out. He is a murderer, a double murderer at that. And all of that was undone, not because of anything the prosecution or the defense did, but because some lady who was a public servant got stars in her eyes and made not one, but multiple bad choices. And it has drawn the worst type of attention to South Carolina, and it undermines the judicial system, and it undermines all the thousands of court staff who work diligently every day in courts across the country, who do nothing of this sort, who keep their mouths shut, who have the best gossip and the best tea you could ever imagine, but they keep their mouths shut because their job is to work for the integrity of the court. Becky Hill is a standout in the worst way possible. Almost no one that you come in contact with who works at these courts are like her. And thank God for that. Thank God there are not more Beckys like her. But unfortunately, she now has created this pall over everyone who really serves the public.
Yeah, and it's just unfortunate. I mean, we could rant about this for a while because the prosecution team did such a great job. The judge was so great. You know, I mean, everyone loved the judge, and it was his last trial. And you just hate that all of this happened. But we'll see what happens. Once again, I think most likely there will be another trial. I don't think the state of South Carolina is not going to not try it again. So it really is just, is there any kind of resolution where the state of South Carolina feels like they have justice for the victims and where Murdaugh gets whatever it is he wants to get out of this? I mean, remember, he did plead guilty to the financial crime. So it's not as if he's never pled guilty to anything. He got 40 years. He's going to die in prison. How far does he want to push this? And if I'm, if you're Pootie Poot, I'm like, how are you going to pay me for this? How are you going to pay me for trial number 2? Yeah, I got no money. And Buster's like, love you, Dad, but I don't think I'm going to pay for it. So it'll be interesting to see what happens, but we'll be there every step of the way.
We will. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs.
Wow, that was cool.
We have like an intro and everything now.
That was
Yeah. Now we should tell people to show up on time instead of wait for how late we normally are.
neat. Yeah. Wow.
You know it's a big case when your neighbor who doesn't know anything about your nighttime life, that sounds bad, but my nightlife is texting me like, what? Alec Murdaugh?
Man.
She's just like a regular person at home.
I tell you what, I got so many texts.
I got a
emails
million texts.
from non-true crime people.
At first, I didn't think it was real. I woke up to this blinding light, and I was transported to another place. Pluto TV! Then I heard a voice.
Come with me if you want to live.
There were thousands of movies and shows, and they were all free.
Truth is ours.
It's just so beautiful.
On Pluto TV, free streaming of Terminator 2, Fringe, Arrow, The 100, and The X-Files may cause excitement, loss of sleep, and sudden belief in extraterrestrials. No credit cards or alien encounters necessary. Pluto TV. Stream now, pay never.